I had a case at the immigration tribunal, which I did for one of my clients. The question of deportation, removal, voluntary removal, these are all terms that people use interchangeably, but unfortunately, there are specific distinct categories that are defined by the laws. Now, to refer to someone who's been removed, that is essentially an administrative process. It's got nothing to do with criminality as such. But for deportation, we're talking about someone who's been convicted, a foreign national who's been convicted for a criminal offense and has been sentenced to imprisonment for 12 months or more. So essentially, deportation is a duty imposed upon the Secretary of State, the Home Department, to deport the foreign criminal. If a foreigner, someone who is not a British citizen, has been convicted and sentenced to imprisonment of at least 12 months, then the UK Border Act of 2007 compels the Secretary of State to issue a deportation order against this foreign criminal. This is a duty and it's not a discretionary one. So there will be a deportation order. So this my client had been in the UK for 20 odd years and he did something stupid and he went to jail for more than 12 months. Now, when he was released, the notice for deportation was there, and of course, we had to file an appeal. Now, the basis is usually human rights or protection. Now, in this case, I was relying on human rights and specifically family life. And that is where the principle of paragraph 399 unduly harsh was very handy. The case was successful based on the unduly harsh principle applied on the relationship between my client and his minor children. There are inexhaustive reasons upon which you can rely on when explaining the unduly harsh principle. Now, in my case, I rely on the fact that the child had special needs. So the expert report that I had about the child demonstrated clearly that the extra support provided by my client and the family setup was very instrumental in stabilizing the special circumstances of the child. When we're talking of unduly harsh, obviously we're not talking of harsh circumstances. So the question to be explained in court would normally be that it would be unduly harsh either on the deportee or on the child or the partner, if there is a British partner or there is a qualifying child. So it would be unduly harsh on either party if the deportee is removed from the UK. And on the other hand, you could as well demonstrate that it would be unduly harsh on either party if the deportee is removed from the UK with the children or with the partner. So whether the partner or the children are staying in the UK, sometimes the Home Office lawyers will be arguing or presenting officers will be arguing that the appellant could be removed or could be deported and the children will be fine. And if the children are not fine in any event, the child or the partner, as the case may be, could go abroad and live with the deportee. Now, you would have to still demonstrate unduly harshness. The successful case I'm referring to was based on paragraph 399 unduly harsh, so the harshness must not be ordinary. Yes, if you're leaving your child or your partner in the UK to go abroad, it would be harsh. But the law is not saying that you should demonstrate that it is harsh.